Okay, we'll begin. Welcome to the next installment of Contract Conversations. In the polls that we've ran following previous webinars, we've received a lot of feedback that people would like a quick refresher on privilege. So today we're going to take a very brief look at privilege. And what we're going to do is focus mainly on legal advice privilege and litigation privilege, which is probably most relevant to what you do on a day-to-day basis. We'll take a very quick look as well at common interest privilege, and then very finally, we'll just give you some quick do's and don'ts of what to do on a day-to-day basis to try and protect privilege. By way of introduction, just before we begin, my name is Mark Davison. I'm the head of international arbitration here based in our London office, and today I'm joined by Catherine Noble.
Hi, I'm Catherine. I'm an associate in our commercial disputes team and I'm based in our Norwich office.
So before we kick off, there is a Q&A function as usual, so please feel free to ask questions. I think we had about 170 registered for today, so we'll try and deal with as many questions as we can at the end. If we don't get to your query, what we'll do, as we usually do, is try and follow up with you separately. So just really quickly, just what is privilege before we start looking at the different types of privilege? So put shortly, all privileges, it's a special mechanism to try and protect the confidentiality of communications. The protection which is afforded is effectively that you're not required to disclose a document which is privileged. It effectively stays confidential unless a client chooses to waive its confidentiality later on. We're quite fortunate here in the UK that we have this special mechanism of privilege, which effectively seeks to give clients this special tool to protect its communications with their lawyers, because a lot of foreign civil law systems don't, for example. So I used to work in the Middle East, and there wasn't the concept of privilege in the Middle East. What they relied on was that effectively communications with lawyers were confidential, but you didn't have the same disclosure obligations that we have in UK proceedings. Equally, other industries have been clambering to try and gain the benefit of privilege for years. So some of you might remember that around 2013, there was a Supreme Court case where the Prudential had sought to try and claim privilege over tax advice that it had received from its tax accountants. And the Supreme Court held in that case that advice from accountants could not be protected by privilege. Legal privilege, certainly in the UK, is seen as a fundamental human right, central to the administration of justice. It's in the public interest that individuals and firms should be permitted to seek and receive legal advice and investigate and gather evidence without losing the benefit of privilege. Before Catherine moves on to just look at legal advice privilege, and we'll start to move through the slides, I just want to address two quick questions of just when is privilege created and how long does it last? So in respect to the question of when it's created, you assess whether a document is privileged by the point of the time that the document or the communication is created. You can't try and seek to gain privilege later on, just for example, by forwarding it to a lawyer. But once privilege has been created, it lasts forever unless it's waived or removed by statute. So it even survives death and dissolution of a company.
Okay, so moving on to the specific types of privilege, I'm starting with legal advice privilege. So legal advice privilege attaches to all communications between a solicitor and their client in relation to a transaction where the solicitor has been instructed for the purpose of obtaining legal advice. As Mark noted earlier, being able to establish privilege is important as it gives the party asserting privilege an absolute right to withhold the document from the world. This type of privilege is not confined to advice purely about the legal rights and obligations, as it covers all aspects of a transaction. However, it does only arise where it's given in the context of relevant legal advice being given, and that comes from the Three Rivers case. For example, if a friend asks me for some advice, legal privilege does not attach to that communication. The conversation or email or whatever might be confidential, but it won't be privileged. Legal advice privilege generally only actually arises where there's a formal retainer, and that's been agreed. So there can be issues if advice is given on a pro bono or free basis. The basic requirements for legal advice privilege to arise is that there is written or oral communication, that communication is between a client and a lawyer or an agent of either, and that the communication has to have been made in confidence and be for the dominant purpose of giving or obtaining legal advice. These requirements seem quite obvious, but there are certain nuances to consider. So even when you're looking at communications, privilege attaches to all communications, even those which are prepared but not sent. It also attaches to notes evidencing communication, whether they're made by the lawyer or a client, and to the lawyer's working papers. And in certain circumstances, those are the client as well. Where the client is a corporate or charitable body, you need to be quite clear over who's authorised to give legal instructions. This becomes important when documents are being created internally by the client. So again, in the Three Rivers case, it was held that documents prepared by the employees of a client were not privileged. And that was in circumstances where those documents had actually been created for the dominant purpose of being shown and sent to the lawyers. The court found that because those documents were created by the employees and not a person authorised to give legal instructions, so in-house counsel or director, they didn't attract privilege. This decision has some quite practical consequences. So in practice, if an in-house lawyer or otherwise authorised employee prepares a document to obtain legal advice, it will attract privilege. But if that person then asks an employee to prepare a note, privilege doesn't attach. And it's not sufficient to say that the employee had authority to communicate with the lawyers on that specific instance, even where the lawyer is in fact in-house. The courts are trying to be quite pragmatic about this. So in the Jet2Com and Civil Aviation Authority matter, the Court of Appeal found that where a communication was sent to lawyers and non-lawyers, it would be privileged. However, if that communication was sent to both a non-lawyer, so for commercial comment, and then a lawyer for legal advice, it would only remain privileged if, in disclosing it, the non-lawyer's response would disclose the nature of the legal advice sought. So consequently, you need to be quite strategic about how legal advice is shared, and that's something that we'll come on to later.
Thanks, Catherine. Litigation privilege. So, put simply, litigation privilege, it's designed to try and protect documents for the purpose of litigation. The test there, as on the slide, is that the communication will be protected by litigation privilege if you can establish that it's first confidential, it's then between a lawyer and a client, a lawyer and third party, or a client and third party. But provided, and this is the key point, that the dominant purpose of the communication is for the conducting or aiding the conduct of litigation, which is ongoing or which is reasonably in contemplation or prospect. Before I discuss what constitutes the dominant purpose, what we mean by litigation is effectively any adversarial proceedings, both civil or criminal. But if you are involved in some state body investigation, do take care to ensure that litigation privilege can be asserted in the context of those investigations or inquests. So my understanding is that litigation privilege might not necessarily apply to Banking Act inquiries, for example. In respect of what prospect of litigation there has to be, it doesn't have to be greater than 50% at the date that the communication is created, but the party that asserts litigation privilege has to satisfy the dominant purpose test. And so what do we mean by the dominant purpose? What is the dominant purpose of why that communication is being created? Because that's the key point. You have to look at, was it created for litigation, or was it actually created for something else? And so courts look at that question objectively. Issues do arise where documents are created for more than one purpose. And so a point where it does commonly arise is, say, something has gone wrong, there's no litigation or state body inquiry yet, but a client decides to conduct an internal investigation to find out why the issue has occurred. So the issue is that because litigation isn't yet on foot, it can sometimes be difficult to assert that the notes of the investigation are for litigation. Worse still, you can sometimes find that internally people have created reports where they've given commentary on the interviews and investigations which have taken place, and they may not necessarily be covered by litigation privilege. So, what I'd say is if you're in that position, what I'd recommend is take a look at the Court of Appeal decision, which is there on the slide in SFO and ENRC, but also try and talk to an external lawyer before you embark on internal investigations, just to make sure that privilege can be maintained. There are numerous cases of where documents have been created for a dual purpose, and there's then been a debate as to whether actually the dominant purpose was for litigation or whether it was actually for something else. And so I think probably the best recent illustration of that came from a 2015 case called Property Alliance and RBS. And so what had happened in that case was that the claimant had met the defendant's former employees and took a note of that meeting. But the defendant's former employees had actually been misled when attending that meeting because they actually thought that they were going there to discuss future business opportunities, when actually what the claimant really wanted to do was to try and find out information and evidence for the dispute that they had with the defendant. And so, whilst the general position is that it's up to the person who is seeking to assert privilege to explain what the dominant purpose of the communication was, so the court will assess it by what is the dominant purpose for the purpose of the person that's trying to assert litigation privilege over a document. The court held in the Property Alliance case that because the claimant had actually deceived the former employees to attending the meeting, it was only fair and correct to assess what the dominant purpose of that meeting was by looking at it from the former employee's perspective. So, namely, that it was there to discuss future business opportunities rather than to discuss evidence for the claimant's claim. And so basically, the court said that actually the claimant couldn't assert litigation privilege in those circumstances. Just very finally, just about settlement. So litigation privilege can also cover communications about settling litigation, but you just need to make sure that it actually discusses settling the litigation. It's not just a general commercial discussion. And that came out of a case which is there on the slide involving West Ham United's move to the Olympic Stadium called WH Holding.
Okay, so just moving on to look very quickly at common interest privilege. Common interest privilege attaches to both legal advice privilege and litigation privilege, and it operates to preserve privilege in documents where they are disclosed to third parties. It's important because that third party can assert the disclosing party's privilege as against the world. So where are you likely to find common interest privilege? Essentially, it's in circumstances where there are two different legal entities and they have a genuine common interest. So we're talking mainly about co-defendants, insured and insurers, reinsured and reinsurers, group companies, so parents and subsidiaries, agents and principals, and in certain circumstances, parties who use the same solicitor. There are practical issues to consider. So the first one is that common interest has to exist at the time of the disclosure to the third party if you're going to try and assert common interest privilege. And secondly, there's been quite a lot of uncertainty and questions raised about the circumstances where common interest privilege will actually apply in any given situation. It's very fact specific. So if you want to err on the cautious side and you need to disclose disclose documents to third parties, you might want to consider making disclosure conditional on the basis of express contractual undertakings that the privilege isn't waived. And that leads quite neatly on to Mark's next point.
So just conscious of time, so very quickly we'll just look at some do's and don'ts. I'm not going to discuss all of the do's and don'ts there on the slide, as hopefully most of them are self-explanatory. But in respect to the first row on the screen, do think about, before you write things down, the way I always look at it is when I'm sending an email is just to try and actually think how would it be perceived when it ends up in court. If you can discuss matters on the phone where you're concerned about privilege, that might actually help you in the long term. In respect to the point that's there on the fourth row about distribution lists, that is important. I know that in large organisations there can be many stakeholders who need to be kept apprised of what's going on. But if you can limit the distribution list, so the number of people that are copied into emails, that can just help make sure that you keep control of that control is kept over the communication, and that someone doesn't inadvertently waive privilege by forwarding it on to somebody unnecessarily without actually thinking through what the consequences of that might be. Equally, in respect to that point next to, the row second from the bottom on the right in terms of the don'ts. Obviously, don't refer to legal advice when you're speaking to third parties. I appreciate that just goes without saying, but you'll be amazed by how regularly we see instances of where clients have written to a third party that they're in dispute with and have said something along the lines of, I've spoken to my lawyer who has said X, Y, and Z. Obviously, at that stage, confidentiality has been waived and privilege has been lost. In respect to marking documents privileged, I appreciate again that this goes without saying for most of you. Obviously, just marking a document as privileged and confidential doesn't make it privileged. You still have to look at what the purpose of the document and the communication was in order to ascertain whether it's privileged. But at least marking the document as being legally privileged helps to try and show what you were trying to achieve through the purpose of that document. I just really quickly want to just address the last two bullet points there, just on the slide. And this has really come to the fore, especially post Brexit. So for those of you that are in-house lawyers that deal with overseas entities, you just need to be acutely aware of how respective jurisdictions deal with privilege. And so the issue over Brexit is, I think, as we all know, that because of Brexit, unless you're qualified and registered in an EU state, you're no longer authorised to give advice on EU law, save to provide advice in respect of retained EU law as it applies in the UK. And so at the moment, you can still provide English legal advice to EU subsidiaries and connected businesses. And you can travel to perform that function, but we'll just need to check going forward whether any member state seeks to try and impose any restrictions or registration requirements for that purpose. But if you are advising EU subsidiaries, you just take care that privilege is maintained. If you're advising on an English law issue, which would be determined before an English court, you should be okay. But if not, you might just want to check what the position is locally in order to ensure that privilege is maintained. In respect of in-house advice, which is coming from foreign in-house lawyers to here in the UK, that should be okay. There was a decision last year called Tatneft, and I can't pronounce the defendant's name, apologies, but that effectively held that advice from a foreign in-house lawyer is privileged, but you still just actually need to go and show what the dominant purpose was for the purpose of the advice that was being given.
So this is quite obviously a flowchart. It's quite a helpful aid to help you determine whether or not a communication is privileged, and you've got the kind of key points to consider down on the left-hand side before you actually start looking at the flowchart. It's really just as an aid memoir, but hopefully it's quite helpful. So we'll make sure it's attached to the slides that will come around in the follow-up email after this.
Okay, so questions. So we've had quite a few. Just quickly address somebody missed the start of the webinar, and we will circulate slides and a recording of this post the webinar. So there's a question here about what happens if privilege is waived. What happens when it's waived? In short, if you've waived privilege, so you've referred to it in a witness statement or you've referred to it to a third party, effectively it's no longer confidential, so that protection is lost. So if it's lost, then what happens is that you have to disclose all the advice that you received as part of what we call the transaction. And so what that means is you don't actually just necessarily disclose the advice which you've lost confidentiality in on the particular issue. What you do is you actually look at all documents around that transaction. So effectively, it's more broader than just disclosing the inadvertent forwarding of an email or the reference to an advice in a witness statement. And so the reason why you actually have to disclose the transaction, so all advice around that transaction, the way I always sort of explain it to clients, it's not actually to punish you, it's actually to protect the other side. What courts don't want is for effectively you to go and cherry pick which best bits of advice you're giving to the other side without actually allowing the other side to try and understand the purpose of that advice. What it effectively wants to do is try and ensure that the other side understands the benefit of the advice which has been waived by getting them to see the warts and all behind sort of all the documents which go around that transaction of that advice which has been waived. I should say that even that you may have inadvertently waived privilege, it's not necessarily always lost. And sometimes you can get it back, and it's what we term rowing back to try and get your privilege back. And so there was a case that was involved in a couple of years ago where we was involved later on, and the witness had inadvertently waived privilege by referring to legal advice in a witness statement, and the other side had said that that was a waiver, and so they wanted disclosure of the documents that they had, documents that fell within the transaction. And so what we were able to argue was that whilst the witness statement had been filed, it hadn't actually got to a hearing yet. So actually the purpose for that witness statement of what it had been filed for hadn't actually yet been deployed because it had not been heard before a court in terms of the application that it was filed for. And the court accepted that argument and said that actually that's right. What you can do is you can take the witness statement and redact the offending sentences. I should just say there was a case, I think, late last year, I think it's called PCP, which is a case involving Barclays Bank. And the commercial court in that case clarified what constitutes a waiver of that privilege. And so in that case, the judge held that even though privilege had been waived, the judge held in PCP, this is in Barclays, that basically, even though the witness statement hadn't actually referred to the litigation advice that they had received, what they had effectively done was referred to the effect of the legal advice that had been given. And so that had constituted a waiver as well. So it's just be very careful when you're sort of considering legal advice that you've been given, or it's something that's protected by litigation privilege, just to make sure that it's not waived. There's a question here about European Commission enforcement matters, and about whether English lawyers' advice to an EU subsidiary will no longer be considered privileged in that forum. It's a very interesting question. And so sort of my understanding is that just great care has to be taken around privilege. I think the problem with the EC Commission stuff at the moment is that obviously English lawyers are treated as third lawyers for the purpose of the EU because we're no longer in the EU. And so therefore, because an EC Commission investigation will concern principles of EU law, effectively what an English lawyer would be doing is giving advice on EU law. So I can see there's a good argument there that it wouldn't necessarily be covered by EU privilege. A way around that might be that if you're part of in-house teams that are dealing with EU investigations, is effectively to structure your advice or the work that you're doing through an EU lawyer, so that the EU lawyer is effectively supervising and approving whatever work that you're doing. There's a question here, Catherine, about without prejudice privilege. Do you want to quickly take that?
Yeah, of course. So without prejudice privilege, just in terms of what it essentially arises in circumstances where there's a dispute. So it's very closely linked to litigation privilege. But it allows parties to exchange correspondence and discussions about settlement in a private environment. So it won't compromise the kind of formal stance that they're taking. Essentially, when you're in WP correspondence, you're saying, I'm trying to reach a settlement with you. Don't admit that any part of your case. I'm not waiving any of my rights. Here's a settlement I think would be agreeable, but by the way, I still think I'm right. It does only apply where there is a dispute on foot. It can be pre-action, but there has to be a genuine dispute. And it also only applies to correspondence where you are genuinely trying to settle a matter. So you can't kind of use it as a shield from everything. If you don't reach settlement, it will still be held to be without prejudice, and it can only the privilege can only be waived with the consent of both parties. Very technically, you don't have to label your correspondence as being without prejudice, but I think it's advisable to do so. It always goes down to the substance of what's in the correspondence, but if you mark it without prejudice, that you're certainly kind of leading the way to say that that's what you expect, and you expect privilege to apply. I would just note, if you're having conversations and you want them to be without prejudice, say without prejudice. Do not say, oh, can we just talk off the record? That isn't privileged, and privilege will not attach to off the record conversations. And then just as a kind of side point, if you are looking to cost, so if you're in litigation and you're looking to settle the matter and then costs are going to be assessed separately, it's always worth marking the without prejudice correspondence without prejudice savers to costs, because that will allow a court to take into consideration that correspondence and the different positions of the parties on the point of costs. So after the substantive matter has been decided, and that also applies if you've settled a matter by consent. So you're just looking to a cost to be assessed if not agreed to order. If the correspondence is only marked without prejudice, the court can't take that correspondence into account on the point of costs. So I think that's probably WP privilege.
I think just given the time, I'll just deal with one more question, which is about a manager in a business emails an in-house lawyer for advice, but there's no external lawyer involved. Will that be covered under legal advice privilege? Catherine, correct me if I'm wrong, but provided that the function of the in-house lawyer is to provide advice, and it's very much the manager seeking legal advice from the in-house function, then for the purposes of Three Rivers, that should be more than fine. So fine. Within the question is that should they mark the email legally privileged? Not necessarily, no. If it once privileged, it's privileged, but at least marking it legally privileged makes it clear to the reader that it's intended to be privileged at least. I think given that it's 3:30 coming up to, we'll end it there. We're going to take a break over the Easter break, but we'll return on Tuesday, the 20th of April. And we'll follow up in the next couple of days, maybe next week, just with the topics that we're going to cover in the first 3 contract conversations in the spring. In the meantime, I hope everybody stays safe and well, has a fantastic Easter. I'm sure everybody is looking forward to seeing some friends in gardens as of Monday. Okay, take care, everybody. Thank you.